You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And guest Martin Pebu has rejoined us. Audrey Gajepo just left us. Thank you so much for making the time. Valerie Blodepe in the United Kingdom says, I couldn't help watching Newsfile today. Dr. Audrey Gajepo on point as always. Sound and sensible submissions devoid of partisan emotions. She's one of the smartest women I have ever known, who taught me at communication school. Samson, please bring her back on Newsfile. I will tell you that is one other problem. Bring her back on Newsfile. That's another problem. My production try, and many times I get some of you, telling me about the need for women to be here on the show. Dennis is one of them, always reminding me, and I keep reminding the production, and sometimes you can't imagine the frustration that the production team go through. They do everything to get women to come on this show. Unfortunately, it's not produced the results that they have always expected. I am equally guilty. Clara is my sister, and sometimes I am overprotective of her. Unfortunate, I can't help that. Anyway, so a couple more.
The production team are not doing enough.
You have to be dynamic.
No, not doing enough.
As for doing enough, yes, I get a fight. So Samuel Dami, there should be some dynamism and activism to get more women on this show. Now, Charles Nyame, in a Saman case, he says, I'm not surprised at the mixed reactions coming from both political divide to the president's gender comments because that has been the norm. However, I am still waiting to hear the voice of Otiko Jaba and Gifty Clenham on this issue before I can make a meaningful conclusion. Well, both women, did they resign? One resigned. Did one leave? Was one removed? I think so. Okay. Why? The president should force them to come back? All right. Cletus Kaba says the president's feminist debate reminds me of something I heard on radio, I think from Pastor Joel Austin, maybe not in the exact words. A certain man lived so well. Oh, that's too long. I can't read that. I'm sorry. Thank you. I can pause here and then we can continue our discussion as to why MPs don't want to be arrested or appear in court. Okay, Senor says that if 50% is to come from Parliament and Parliament is dominated by men, what stops the president from appointing women from other, to form the other 50%? Thanks for your message there. Just want to read just one more here and then we proceed. Daniel Batidam, thank you. He says that I like the way my communications professor Audrey has taken control of the discussion in the studio. I think this is probably what our president wanted to advocate. So we should do a lot more to get women voices. They always deal with the issues in a better perspective. This one from Dr. Park, he says the president goofed. How could he say women have not shown enough dynamism and activism to get a place at the decision-making table? His claim is factually inaccurate, simply not true. Women in Ghana have and continue to advocate and to show dynamism. The president needs to apologize for accusing Ghanaian women for not doing enough. The challenges are structural and systemic, not lack of effort by women. We can look at how to change the existing structures and systems, formal, traditional, and cultural, preventing more women from getting to the decision-making table. That's what many expected to hear from the president. Clement Park, thank you very much. Now, Martin, let me start with you once again. Did you understand Ayaraga to say that the special prosecutor has criminal charges against him, yet he's MP, so he won't show up in court?
No, at all. Far from it. So in his own letter, my understanding, okay, and also from the speaker's certificate, is that he's saying he has partial immunity. Specifically, in this context, it will relate to the dates he has to appear in court. Okay? So from the Constitution, it's clear that an MP doesn't have immunity from prosecution. No, not at all. But rather, so we are looking at 122. The thing is that don't impede him in his parliamentary work. So if you look at it practically, so if you're looking at Article 122, okay, if you are looking at 117, if you are looking at it practically, what it involves is that arrange in such a manner that he gets opportunity to attend court and also gets opportunity to participate in the work of Parliament, because he's been elected by his constituents to represent them there. So you don't prosecute in such a manner that he's not available to perform the duties bestowed on him as a parliamentarian. Okay? Yeah, so looking at even the Speaker's certificate, the Speaker, in the ruling, which was attached to the certificate, the Speaker made references to precedent where during the trial of Dan Abu Dhabi, the trial was structured in such a way that he went on Mondays.
Right.
And you see that even at the end of the proceedings, that's Ayarge's case, the case was adjourned to Monday, term view. Yes, so that tells you that we are on a certain trajectory. Okay, yes, so
if the judge was predisposed to allow this space, why was she insistent on Ayarga appearing on that day? Was it Wednesday?
Tuesday.
Tuesday. Why was she insistent that Ayarga must appear? And it was very clear, the warning was clear, that if he had not appeared, he would have been in trouble.
Okay. Yes, and that particular one, that's what, oh, well, good. That being in trouble, I was wondering what it meant. Do you know what I prefer to do? I think that in matters like this, it's better that we're a bit cautious, okay, to the extent that we're not in court. To the extent that we're not in court. Because, you know, when journalists have to report, they are not trained like us, so sometimes they may miss out a thing or two. So for me, once I wasn't there, I didn't see, I would be cautious, this insistence on the attendance. Because from what I hear, and in the news, he had not been served, okay? And you know now we've moved. You see, we can't be here to say that, oh, since when did it become the law that you should be served before you come? No, we know that from practice, the police like to call on the phone. But I think we've moved away. You see now the AG files the charges 2 weeks before trial. And you know, this filing charges 2 weeks before, this is something we're doing in the 1870s. It didn't start today. See, so we've gone back to Sankofa. Yeah, those days we had the Judicature Act. Yeah. It provided that minimum of 14 days before the trial, serve the accused. So it's good that even summons. Without, yes, with the summons, so the charge sheet and all that. So it's good that even without express law, we have gone back to 1876. So me, since I saw the AG engaging in this practice of serving 2 weeks before, I'm like, okay, good. Ghana gone back, Sankofa. Okay,
but so that is dictated by the circumstance. If not so, because if they arrest you today and we are a subject, they are not interested in granting you bail and they cannot keep you beyond 48 hours. Yeah. There's no point to serve you anything. They keep you until they produce you in court.
Yes, yes, that's correct. That's for those ones. So, yes, an option, but you see, the age is shown the way that, look, let's begin to do things well. If over 100 years ago we knew how to serve 2 weeks before trial, why is it that in this day and age we just call on the phone, hey, show up? Okay, so I'll say that, you see, bottom line, you see, it's about looking at it, the substance over the form. So initially she insisted, she stood it down. I'm not, once I was in court, I don't want to fault her because I don't know if she was aware that Mr. Ayarga had not been served. You see, if he hadn't been served, why would they insist? You see, so let's look at this, the substance of it moving forward.
Sorry, the court has a way of knowing whether somebody has been served a process or has not been served.
Yes.
So on the docket, it would have shown that he has been served. Okay. The special prosecutor or its representatives were in court. They would have been asked, have you served?
And Ayarga had his lawyer in court.
Yes, and Ayarga's lawyer was in court. Except that what we are told is that once the case was called and they had a motion to move because they had issues with some of the charges and they wanted to throw it away. So once it was called, that's a criminal case where is the accused? So that's the first question.
Yeah.
The accused must stand. Where is the accused? The accused is not available. It must actually get into the dock. The accused is not available. And the judge looks around, can't find an accused. So the instruction of the judge is, I want the accused person here. And I want the person here by 1 p.m., is it?
Yeah.
Yeah.
Yeah. So, Sam, you know very well that, look, it happens a lot in the court system. The judge has a docket. There may not be proof of service. So you see why I said once I wasn't in there, I haven't seen with my eyes, I'll be very cautious. Oh, it happens all the time. You go to court, sometimes the bailiffs have served, but for the proof of service to get onto the docket, it's another long journey altogether. Yeah. So that's why I just said it's better we just look at the substantive part, moving forward. What do we do to avoid such a skirmish? Because you know that it's even been blown in a way, let me say, out of proportion, making it look like there's a clash between the legislature and the judiciary. No, this morning, because of that, I specifically spoke with Eduji, that's one of our youngest lawyers, just to get a sense of what happened in court. And he mentioned this several times, and I said, Eduji, can I quote you? He said, yes. He said, look, he doesn't see any clash. That's lawyer in the case. And I said, Eduji, can I quote you? Because, as I said, I was eager to get a bird's eye view, get a good sense of what happened in the court. And since he was lawyer, at least. So if even Mr. Harrigan's lawyer says he doesn't see the clash, then it tells you that, yes, something went wrong a bit. We shouldn't blow it out of proportion. You see, we shouldn't blow it out of proportion. What we know is that from the Constitution, it's clear that he has a partial immunity as long as he's engaged in the work of Parliament. Don't do anything to obstruct that work. And so from precedents, usually what you do is that you structure the court hearings, the sittings, in such a way that he can perform his work in Parliament and also come to stand trial. You see, and maybe it's for good reason that you know that even apart from the Constitution, you know, it's provided in the Parliament Act 300 specifically that you cannot serve an MP with criminal process without the permission of the Speaker, Section 20 of it. Yeah. So this brings me, the ADG mentioned to me that they had sent the summons to the Speaker, which was wrong. So he must first seek his permission, then the service is done. But I understand in this case, the summons were sent to the Speaker, so they returned it.
So the special prosecutor did the wrong thing?
Yes, exactly. So I understand the Speaker, they wrote a cover, the clerk wrote a cover note on it, and then they returned the process, seek permission, then it's granted, then you serve. Because you know what, I mean, we're talking about Eskime, which edition is in vogue now. Yeah. In Eskime, when you check, it's clear that, look, even in Britain, where we copied these provisions from, when I say Eskime, that's there's some parliamentary practice.
Our Bible.
Okay, yes, exactly. That covers the privileges and all that. At page 155, they make, and I'm talking about the 20th edition because I understand there are newer editions. Yes. They say the arrest of an MP and the rest, it's not contempt. It's not contempt of Parliament. And they make it clear also that, look, listen, it doesn't, the privileges don't cover criminal prosecution. No. So if there's a crime, the MP must be made to stand trial. But then, as we stated, it involves practicality. Do it in such a way that the MP gets to perform his function as an MP, and then he also attends trial. Perhaps this struggle for dates, maybe on the side, I should mention, you know, we've called upon the Supreme Court to look at the matter of perhaps opening the courts on Saturdays and Sundays. Yes, so if throughout the week he's busy, because, you know, we do that for SNIT. For employers who owe SNIT, and then also electricity. Okay, so electricity and SNIT
work
cases.
on Saturdays.
They work on, so maybe we should look at it, put that kind of rate before the Supreme Court.
And sanitation.
Now, Roxanne.
Yes.
So clearly, it is not true when the Constitution says all of us are equal before the law. You, the MPs, are not exactly equal.
We are.
See. And the manner in which the AG has started that, Pebu is commending, where they issue the summons. Yes. They file, and then you get to know long in advance.
Yes.
Assemble your lawyers and get prepared for it. You see who they have been doing that to? Do you have a client they've done that to before?
No.
They do it to ex-appointees and MPs. They don't do it to the ordinary Ghanaian. That's what I mean by
let me disabuse your mind.
So what's your understanding?
Okay.
Reading, particularly like he also shows, Eskime,
Yes.
that your understanding is that you ought not be arrested even if you are committing murder on the street and a policeman sees you because you are going to parliament or you are from parliament. What is the problem?
Okay, let me say this. There's a bit of confusion in respect of understanding the procedure involved. We're all equal before the law, and that cannot be undermined in any way. Indeed, if you look at the relevant clauses in the Constitution, they even speak of the Speaker. So it means the Speaker can be arraigned before court. Yeah. If there's an allegation of commission of crime. Indeed, the clerk. But in our Criminal Procedure Act 30, there's a certain procedure to doing that. There are two options when prosecution wants to arraign a person before court. You either arrest, okay, then you interrogate you investigate by way of interrogation. If they have enough evidence to prosecute, they prefer the charges and arraign. Okay? If they are willing, they will grant what they call police inquiry bail, pending that. The other option, which they don't like to utilize or to use, is the preparation of criminal summons. Okay, there's an allegation of commission of crime. They may invite you to take statement, or they may not take statement at all, but they will investigate the matter. If the evidence is such that they must prosecute, they have to prepare the criminal summons and have you served. So it is the service of the summons that is an issue. Now, the Constitution is very clear. It appears that everybody gloss over the use of witness in the Constitution. Now, the interpretation is that when you are a witness, then this is applicable. The process being spoken of is applicable. But where you are not a witness, then the other stipulations in the Constitution impeding the work of the member has to be interpreted.
Yeah.
Now, is the service of summons when you are on your way to Parliament, would it impede your work? If you think so, then the leave of the Speaker must be sought. And indeed, my understanding is that there are a lot of MPs that have been served criminal summons in this Parliament. Not in the 7th Parliament, but in the life of this Parliament, the 4th Republican dispensation. What is done is that a leave is sought of the Speaker, so the Speaker is notified of the process. Then the Speaker in chambers will invite the honorable member. Then in his presence, the process is served on the person. Then that ends it. Then it behoves on the person, whether it's a civil process or a criminal process, then you take steps to respond. That will not be the business of the Speaker. So, bringing this matter home, the impression is created as if the Honorable Ayariga is unwilling to submit himself or to defend himself in the matter. I don't think so. And so that impression has to be dissipated today. He's a lawyer, he's a trained, he's a very sharp lawyer, he's done a lot of work. I don't think he's scared of court. But he says, look, you have come to the Speaker to seek his leave, to take even his statement. Okay? You used a similar procedure. You have even searched his home to look for evidence. He allowed you. You have even gone beyond that to procure content of his phone records. You've gone to do that. Now, you have also tried to interrogate him. He submitted himself. Okay? Or using the similar process of making himself available. So why would the service of the criminal summons not follow a similar procedure? That's all that he's saying. All right? So that is where the issue is. And in respect of this other impression of Parliament having a confrontation with the judiciary, the court in question, I don't think it was the case. And this was what happened. In practice, even when we are taking dates, we negotiate the dates, either to the convenience of the lawyer on the other side or even to the court. Where two lawyers at the bar suggest a date that it's not convenient for the court, it doesn't happen. Where sometimes the court suggests a date, it's not convenient for even one of the lawyers at the bar, it doesn't happen. We haggled over this until we get, that's why it's called a convenient date. Okay. Now, in this matter,
Dennis is having a laugh, you know, because
no,
because you know for a fact that some of the judges have become clearly aware of how the lawyers abuse this kind of privilege, and so sometimes it is not at your discretion. And if you have gone in these courts around where Ayarga was taken, the two courts in particular, the ladies in those courts.
Sam, let me do this.
Hold on. Martin is saying it's true. I don't know what he's saying is true.
No.
It's true that
You speak of, do you know how many, hold on,
Yeah.
do you know how many judges we have? Right from the lower courts to the superior courts. I speak of a practice that has become common.
Okay.
You speak of exceptions. If 2 or 3 judges have decided that we think some lawyers are abusing this, so we won't grant them this discretion, that is fine.
We're talking about judges that you can tell manage their court so efficiently and effectively.
I still speak of what we do in practice. Okay? So I'm saying that prosecution, defense lawyer, and the court, they can agree on a convenient date if the court is so minded. Now, what is the issue? The issue is that prosecution goes to court on a date appointed by the registrar of the court, fixes a matter as captured in the court list, and you don't go with your accused person. This is criminal law 101. Is the court seized with the matter to deal with it and make consequential orders? In my view, no.
Okay.
All right? In my view, you are not seized with the matter.
So the court shouldn't have been inviting
Ayarga. You should be asking.
You think the court was doing the job for the prosecution?
Exactly. You should be asking prosecution. What is your business? So go back and put your house in order.
And bring your accused person.
Exactly.
Okay. Dennis disagrees with you. Let's hear him on that. He disagrees.
So Samson, let me put this issue in context. I am more concerned to speak as to what happened in court, because I was fortunate to have another matter there. When the case was called, the accused persons, as in terms of the practice, the accused person, and the 7th accused person, because Ayarga had 2 cases that day, the 7th accused person, the first case that was called, his lawyer was there. When the judge asked, where is the 7th accused person? His lawyer's response is that he is in Parliament. The judge says, go outside and concede, I want to see the accused person here. That's the answer that the lawyer gave to the judge. Okay. Now, in terms of criminal matters, okay, the judge is not privy to the issue of service was never raised before the judge. Secondly, when you think that you have not been served with a process, but yet still you decide to send your lawyer.
You are wrong.
Let him finish. Yeah.
When you have been served, if you have not been served properly with the process, and you go before a court which is seized with the matter, and you do not raise the issue that you have not properly been served, but you seek to give another excuse, not bordering on the fact that you have not been legally served, I don't think a judge is wrong in any way to decide that based on your explanation that you are giving to the judge. There are instances where criminal matters, you tell the judge that, oh, my client could not be in court because he has a health reason, represent the health, and the judge looking at the second because he's there to deal with justice emanating from the people. So if you give an excuse to a judge that on grounds of health grounds, my client could not make it in court, most judges magnanimously always concede to that fact and decide to adjourn it. Secondly, the position of the law as to adjournment, as established by case law, is that adjournment is at the sole discretion of the court.
Yes, but that's what I've said.
But so we should not make it as if we have automatic right to insist
he
on
says
that.
that's what I said.
I'm just saying.
Convention.
That is not what you said.
Yes.
You said it ought to be at the convenience.
Yes,
It ought
but
to
it
be a
is not. It
convenient
is not
day.
at the convenience
Yeah,
of the
but
party.
that's
Now give us this
No,
education.
but
Give us this education. Dennis, give us this education.
You have made a point.
So if Ayarga's lawyers had told the judge or the court that he had not been served, what would the judge have done?
I think if they are told the judge, because of the nature of the matter, my expectation, the term of strategy might be different, was to file a process seeking to say that he has not been properly been served in accordance with law. But the application that they have filed so far that I've come to notice, and I'm restraining myself, relates to more or less the content of the charge sheet which they are seeking to challenge, and not on the service. That's what I'm aware of. So I am saying that I don't want to even go to that argument about service or non-service. I'm looking at the judge sitting at that particular moment. What was the issue before her? The issue before her was that an accused person failed to turn up for court. His counsel did not raise issue that he has not been served in accordance with law.
My question is, answer it so we'll help educate our viewers and listeners. If the judge had been informed that Ayarga had not been served with the summons at the time, what would have been the decision of the judge?
Most likely, speaking from the bar, most likely the judge could have agended to us interrogate it, asking whether, because the court have clearly established in Barclays Bank with Ghana Cable that when the issue of service is raised, the court will have to interrogate it. So my expectation with a very experienced judge, Josephia Butchie, she would have maybe agenda the matter and say that let me find out whether or not he has been said. That's when the proof of service issues come in. Okay. But once the issue of service was never raised, the judge did not err in any way in insisting that the accused person must appear.
Okay. May I correct this impression? Eduji was in court in respect of 2 motions, all listed for the same day at 9 a.m.
Yes.
You understand my point? So he was not in court for me for the arraignment. And let us get this very clear. Now, when the issue was raised regarding the whereabouts of the Honorable Ayarga, as at about 10 a.m., when the matter was called, and he had to respond. Yes, we've been in practice. And honestly, if I were him, if I were in his shoes...
I moved to Kweku in 2 minutes.
Yes, if I were in his shoes, I wouldn't have reacted. Yes. Honestly. Because I was in court in respect of my 2 motions. The applicant may not be in court. If you ask me in respect of the applicant in the matter, then I can speak to it. But if you're asking me in respect of the arraignment, the absence of an accused to be arraigned, I won't speak. Okay. So prosecution would have spoken to those issues. You understand me? So it is not the impression that he was in court.
Thank you.
In the absence of his counsel.
What do you understand? What do you understand generally about the positions about taking MPs to court or arresting them and so on and so forth? And I can see, like yourself, you have KB Ayesu and SN Dakwa, their book on the evolution of the parliament in Ghana and the functions, the role and functions of our parliament. Martin Pebu is also reading over that. Yes,
a fantastic book.
Yeah.
I was fortunate enough to get the revised editions only last week.
The old one you have needs to rest. I think that's why they've gotten the new one.
That's a good one. You know, sometimes I ask myself why some of these issues persist, in spite of the fact that we've been dealing with them for a very long time. Various precedents abound in our own history. Okay, let me just refer you to something here. See, as far back as August 5th, 1971.
Hansard.
The Hansard, yeah. This is a statement on an arrest of an honorable member. It was done by E.K. Nate Oladga, Justice Party for Adan, the Member of Parliament for Adan. It was Dr. Obeda Samoa who had been arrested by the police. And in fact, he was eventually prosecuted. Fortunately for him, he was acquitted and discharged somewhere February 72. but he was arrested in August. And all these questions we are raising today were raised. I'll just read a certain portion and see that we are just recycling. See, when it happened, after this member had raised the issue, the speaker referred the matter to the Privileges Committee. And the committee met and submitted a report. The report was read to the House by the leader of the House then, Mr. J. Kwesi. And the Attorney General was called to assist the Committee of Privileges in dealing with these issues of when can you arrest, when do you arrest, where do you arrest. All those things that we've been discussing were raised. And that time, this immunity thing was Article 93 of the 69 Constitution. Okay. I'm not sure it's the same thing now. It says, on the provisions of Article 93 of the Constitution, the Attorney General stated that the interpretation and import of the words "on his way to," "attending at," or "returning from" any proceedings of the National Assembly was a matter entirely for the Supreme Court to determine, and not a Committee of Privileges by virtue of the provisions of the Constitution. He, however, said that in his opinion, the words "on his way to," "attending at," or "returning from" any proceedings of the National Assembly meant that if the member was indeed attending or returning from a sitting of the Assembly or committee of the Assembly, such a member could not be arrested within the precincts of the House. On the other hand, if a member sets out from his constituency on, say, 5th August to attend a sitting of the House on 6th August, that member could be arrested on that day, that is 5th August, when the House was not actually sitting. A member, while returning to his home from a sitting of the House, could not be arrested until he left the precincts of the House.
You know what you just read?
Yeah.
It's Eskime.
Exactly.
Where they are learning the tradition. This is exactly what is captured in that book.
So I'm sure he picked it from
there were references to Eskime and this.
So do you find that they try to stretch it beyond what it should be within the precincts of Parliament?
Yeah.
Okay, go
and they said that Attorney General informed the committee that he was preparing a National Assembly bill and that he would submit the draft bill to the committee for his comments before it was published. He suggested that the committee could spell out for the inclusion in the bill the scope and limits of the privileges of members of Parliament. The committee accepted all the points raised by the Attorney General. Now, post Obeda Samuel's issue 1971, we have had an Abu Dhabi. Indeed, the current president was then the Attorney General. He came up in Parliament and he made some comments on it, and it was agreed that the Parliament and the judiciary should find ways and means of fashioning out how to proceed on these things. I hear people still saying these things. We've had Obi Amwa. Che Mesa got up. I brought all the hands side here. Got up and made a case. You remember Obi Amwa was left a meeting, a committee meeting at the La Palm Beach, going home in order to go and dress up and return. The police followed him and arrested him. Okay, we've had E.T. Mensah. We've had so many issues. The same arguments keep happening. And why aren't we able to consolidate a procedure as to how these things should be done? We've had members of Parliament who have been prosecuted and convicted.
Yes.
Dan is one.
Yeah.
Okay. Kennedy Japan was discharged and acquitted. He was going to court consistently. Okay, many of them, the list here. So what is the problem? Why is it that each time a member of Parliament has any encounter with the police or the security services, we come back and recycle the same argument? I don't understand it.
Yeah, Dennis,
aren't we capable of by consolidating the procedure by now, a convention or whatever?
Forgive my voice.
I think it's a prosecution.
Exactly.
We terminate at 12:10. Okay. Tell me this. What's your understanding of the position of the law? Number one.
I'm sorry. I would want for significance. The current president,
right,
as a member of Parliament, he was also invited, if you recall, the Rawlings tape affair. And when he got to the police station, they charged him provisionally and then granted him bail. At a press conference, this is what he said. even though I submitted voluntarily to the police in order to avoid any accusation of attempting to evade responsibility. There is a genuine constitutional doubt as to whether a sitting member of parliament can, whilst parliament is in session, as it is, be subject to legal process, whether civil or criminal. That matter will be taken up on an appropriate occasion.
Okay. Okay. So
this is November
right.
1999.
Let's
20
quickly,
years down the line.
Let's quickly speak briefly to Samuel Intim Dakwa, former clerk of parliament, worked in all 4 republics, and he is
It's an institution.
and a disco old boy.
Don't just say it's an institution.
Yeah, he's an institution. His books are the ones we are referring to currently. Thank you very much for joining us on the phone, sir.
Hello, thank you.
Right. So what is the problem? Do you find that it is the case that the MPs insist that they cannot be arrested, or that they should not be taken to court to be prosecuted?
No, I'm afraid if a member is accused of criminal offense, I think that does not give him license to say that he will not appear before the court because he is privileged to do that. In fact, if you are actually indicted in court, it undermines your own integrity and your effectiveness is reduced. Your integrity is also compromised. And therefore, an earliest opportunity should be given to an MP who has been accused before the court to go to the court and establish his innocence or otherwise. Otherwise, you cannot effectively and efficiently represent your constituency. And therefore, I advise that behind the scenes, there should be no confrontational cause, in fact, between the parliament and the court. Behind the scenes, they should arrange in such a way that an earliest opportunity should be given to any member who has been accused of criminal offense to go and establish his innocence or otherwise.
As clerk of parliament for the longest time, did you ever come into an encounter like this where, because the privilege is extended to you, clerk of parliament, speaker of parliament, and the members of parliament, have you ever encountered such a situation, and how was it resolved?
As far as I could recollect, I don't think any member was arraigned before court for any criminal offense, except that I think Mr. Abodope and few others were accused during the Fourth Republic for financial malfeasances. And I think they attended the court regularly, because if the speaker is actually informed or given the notice that the member is wanted in court for such an offense, I think the speaker will normally grant him the permission to go, and go as early as possible to establish his innocence or otherwise. Because for a member of parliament, you should not be in a position where they accuse you of moral turpitude or corruption or anything of that sort. Because if you are accused of that and you are not freed from that accusation, you cannot effectively represent your constituency. And in any case, a member of parliament, well, you cannot seek membership of parliament if you are a criminal. And therefore, if you are accused of being a criminal, you should go as quickly as possible to establish your innocence or otherwise.
You fortunately worked with the drafters of the 1992 Constitution. What was the rationale for this particular provision for MPs, the clerk, and the speaker?
I beg your pardon, I couldn't hear properly.
I'm saying that fortunately you were part of the drafting
right.
of the Constitution.
That's
What
right.
informed these provisions? Article 117, 118, and 122, correct?
Yeah. That's right. I think, first of all, you see, the presence of members of parliament is required to do business in the House. First of all, there must be a quorum of 1/3 of all the members so that business can commence. Without quorum, parliament will not begin its business. And even after the speaker has announced that there is quorum for business to commence, at the conclusion of debate, parliament cannot take a decision. In fact, the speaker cannot put the question, that is, decide, ask the members to decide as to whether they should accept the motion or not, or the bill or not, until they have about half of the members present before they could take decision. In the First Republic, for example, if you have 1/3 of members is present to commence business, the same 1/3 can take decision. But then when they were making amendment to this, they felt that majority of members of parliament should be present to take a decision to affect the whole country, not minor, small people like 92, the quorum 1/3 of 275 will be about 92. And he says that before a decision is taken in parliament, half of the members must be present before that decision is taken. And even in other cases, it's about 2/3. So to prevent a member from going to parliament, they say it's a serious matter. And therefore, they should be free to attend parliament. But when a criminal allegation is made against you, you must take the earliest opportunity to go and establish your innocence.
Thank you very much, Mr. S.N. Dakwa, senior citizen. And in fact, we would educate ourselves the more on this subject in your book, in how our parliament functions. There's a chapter in which you treat the question of immunity. Now, Dennis, it was Dennis who was on. So I was asking, as we understand, relative to Ayarga, as we understand, he was not served, and yet he went there. Should he have gone once he was not served? Apparently, it was when he went to the court that they gave him the process.
First of all, when it comes to service of process, I think that he ought to have gone. In my respectful opinion, because of the nature of the sermons and being of a criminal nature, and because of the fact that he being a member of parliament and having commented on even the proceeding that was about to take place the same day, it would have been very difficult for him to make the case that he's not aware that a summons had been issued for his arrest.
Can a judge take a judicial decision against him when there is proof that he has not been served? No, in a criminal matter, can a judge do otherwise?
No, I don't think the judge would do otherwise. However, that's what I'm saying. However, that day, that's why we need to situate the issue in the context. What happened within that 5 minutes where the judge asked the lawyer for Ayarga, where is the particular part? Maybe the lawyer might say that he was not allowed to give an explanation because the judge came to the conclusion, I still want to see the accused person in particular. But most importantly, it's about speedy and effective justice. And I think that we should not, as it stands now, fortunately the issue of service, in my opinion, is over. There's a real issues and real concern that they have raised. And for that matter, we should draw attention to the issues that are at stake so that we can...
We will not discuss those issues. We can only discuss these tangential matters, so to speak.
That's fine, but I'm just saying that in my respectful opinion, the issue of service for me, for now, as we speak, because Ayarga has gone to the court, is now moot. So I will not even decide to go into it.
Right, so if this judge wanted to be harsh, you will see that, and again, I talk about all equal before the law matters. If it were an ordinary person appearing before this court and the person was not available, the normal thing a judge may have done would have been to adjourn, would have been to issue a bench warrant for the person to be arrested and then adjourn to the next date. She didn't do that. She only said, I'm willing to allow you some time enough to come? Or even he could close work from Parliament by 3 and come to the court?
Yes. As I said, remember, what I want to establish is that most courts, and by our practice, are not trigger happy to issue bench warrant.
Okay.
I have seen an instance where a judge will give an opportunity for the person to be brought. It's sometimes based on what you tell the judge. What you tell the judge is saying that my client, the accused person, is in Parliament. The judge says that if he's in Parliament, he'll finish parliamentary work by 1 o'clock. I want to proceed with this matter. And for that matter, decides to say that our adjourn it, have a discussion, let the matter be adjourned to 1 o'clock. And I think that before any judge will proceed to make a bench warrant, he will definitely interrogate whether or not the person has been said.
How should MPs be treated in matters like this, being arraigned? How should they be treated?
I think that there should be more communication between the prosecution and the accused person's counsel. And if there's communication, the same is brought to that. As I said, by practice, most of the time the court will concede when both parties at the bar are willing to. So there should be more discussion, and possibly, if there can be a practice direction, okay, where the Chief Justice can issue a practice direction when it comes to the MP, so that there's no longer an issue. Some issues revolving around, there's MP for Senate, Grace Coleman, there are so many of them. So we can decide to issue a practice direction which gives how MPs are supposed to be served and all these issues when they are supposed to be brought before Congress.
And their cases should be heard only on Mondays when they don't sit.
I think that in terms of speedy and effective justice, it should more or less be a discussion between the bench and the bar to decide. I don't think Mondays
30
alone is
seconds.
enough.
30
yes,
seconds.
yes.
30 seconds.
First of all, immunity issues are matters of law. And so where the Constitution clearly says that when in certain circumstances you are immune from a certain process until certain conditions are met, I think we need to respect that.
Yes.
Now, in this matter, Mondays are convenient, I think, both for the court and for the accused person. And I think we need to respect that. Given the background.
Did the immunity that was being sought apply in this
does
matter
not.
because he was an accused
Yes.
and not a witness or not being served the process?
Hold on. You see, it's also one issue because people think that the judge attempted to construe a constitutional framing. Now, yes, I'm an accused person before your court, but by my standing in society, I'm a serving member of Parliament. A criminal process is supposed to be served on me.
Okay.
It has to follow a certain procedure. That's all the matter.
Thank you. Matthew, some 30 seconds.
And Ayariga asked for
30
Monday.
seconds. How should they approach it going forward?
Oh, we should go by the law. Act
Yes.
300 says that in order to serve a process on the
Seek leave
MP,
of speaker.
please pass it through the speaker. You have to apply to him.
Okay.
And the president agreed
Thank you.
20 years
Thank you
ago.
very much. My guests have been Dennis Ejay Jumo. He's a lawyer. Earlier we had Professor Audrey Gajepo, Dean School of Information and Communication Studies. Roxanne Nelson Dafamapo is a lawyer. MP Saudai, and Abdul Malik Kweku Bako, Editor-in-Chief of the New Crusading Guide newspaper. Of course, I just finished up with Martin Pebu, who is also a lawyer. We're joined on the phone by SN Dakwa, a clerk, former clerk of Parliament, the longest serving, we're told. Thank you very much. Have a good afternoon.